personal injury trial attorney Neil Regman, coming at you from the Taconic Parkway on my way to Supreme Court in Poughkeepsie, New York. And I want to take a moment and discuss the different courts that exist in the New York State court system, because they're a little bit different than you might expect and a little bit different than the United States government, which leads them to be confusing. In the United States government, the highest court is called the Supreme Court of the United States, whereas in New York State, the highest court is called the Court of Appeals. So that's a little bit different. The Supreme Court in New York State is the trial level court, and that's where we do most of our work and where we file most of our cases, in the Supreme Court. Now, the court system in New York, the lowest court is called the Small Claims Court. And oftentimes I will tell people that call me that they themselves can file a case in the Small Claims Court if they have a case that's worth less than $5,000. I often tell people that you could do it yourself for only $15. It might be $18 or something, but it's pretty inexpensive. And all you have to do is go over to the courthouse in your county and file the papers, which that really just includes putting in your name and the name of the party that you're suing and how much you're suing for, and paying the fee. And then the court themselves will serve the other party with the lawsuit. And for a small amount of money like that, $5,000, you don't have to get a lawyer involved, you don't have to pay a lawyer's fee, and you can do it yourself. And then they'll give you a court date, and you appear at that court date, and then you yourself are going to present evidence either to a judge or to a mediator, which is more likely. And when you go to a mediator, generally speaking, they help you come to a conclusion with the other side, and usually it's done pretty quickly. That's if the other side shows up. Oftentimes the other side will not show up, and you can request that a default judgment be entered against them for an amount that you feel is fair. And then at that time, the next thing that's difficult is you have to hire a sheriff to execute that judgment, which means they have to go and explain to the person who you sued that they owe this money, and if they fail to pay, they could get arrested. So in any event, that's the how you file in the Small Claims Court in a nutshell. Now, the next highest court is called the Civil Court, and that is the court that you would file for cases that you believe are worth less than $25,000. And again, this is something you could do yourself, but generally people get a lawyer to do it. Now, with our firm, we generally don't take on cases that we feel are worth less than $25,000. We have kind of a cutoff of $100,000, because remember, we get paid on a contingency fee of 1/3 usually, and so we really can't afford to undertake cases that are worth less than $100,000, because we have too much overhead that we have to pay out in terms of salaries and rent expense and all these things. So, in other words, the amount of work that is required to be done on most cases does not justify the fee on a $25,000 case. There are some times where we will undertake that sort of a case because we don't know the policy limits when we initially undertake the case, and so we do it, and we take on a lot of car accident cases that only have a $25,000 policy, because, like I said, when we sign up the client, we're not clear, or we don't know that the other side only has a $25,000 policy, and by then it's really too late for us to reject that case. And we have a system in place where we have a lot of efficient processes that allow us to undertake some of these smaller cases if we have to. In other words, we have like a good assembly line system, whereas we have a lot of people and companies that help us file different documents in a very efficient way to get it done. But generally speaking, we don't want to undertake cases that are valued at less than $100,000. Anyway, getting back to the court systems, the civil court is also, as I was saying, cases where you feel your case is worth less than $25,000. Now, if you have a case that you feel is worth more than $25,000, up to many, many millions, you bring that case in the New York State Supreme Court, which is also known as the New York State Trial Court. Okay, so that is the case we use. That is the court we use to bring all of our cases for the most part. Now, a little side note: sometimes the case can be removed down to the lower court. It starts out in the Supreme Court, and then it can be removed to the lower court for a variety of reasons down to the civil court. But, by the way, you are not constrained by the $25,000 if your case gets removed down to the civil court. You're still able to sue for that amount that you feel is just, based on whatever criteria. It could be pain and suffering, it could be lost wages, or it could be medical bills. Whatever it is, if you brought the case in the Supreme Court, and for some reason the court, sometimes when the Supreme Court is very backed up with a lot of cases and the civil court does not have many cases, the upper court can on their own remove the case to the civil court to basically expedite the process, which is good and bad. It's good because the case gets moved more quickly. Generally, it's bad because the judges in the civil court are not as experienced as the judges in the Supreme Court, and so that's really where the new judges go, the civil court, in order to get experience, and then they get promoted up to the Supreme Court. So you're dealing with the judges that are not quite as experienced as the judges in the Supreme Court, and generally speaking, you want a judge that's more experienced to handle your case, because they're just going to make rulings that are based on the evidence a little bit better, and they're going to have more experience, and generally speaking, they're going to just be better at their jobs, and that's kind of what you want as a lawyer. But in any event, getting back to the situation with the different levels of courts, as I was saying, generally speaking, we bring our cases in the Supreme Court, and we do that normally when all of the parties live in New York State, and one of the bases for the actual venue means the county where the case is brought, is the location of where one or more of the parties lives. And generally speaking, we like to bring our cases in the Bronx County because the jurors in the Bronx County, generally speaking, have more sympathy for an injured client. They tend to give larger awards to people that are injured, and I'm not exactly sure why it is, but maybe they have experienced certain injustices in their lives, and generally speaking, they seem to feel that more adequate compensation is necessary. So that's the first place we try to bring a case. The second place is Kings County, which is also known as Brooklyn, and that's the next place that is the most, I would say, empathetic or sympathetic to injured parties, so you want to bring it there. The third place would be